revisit this Cestui Que Vie Act of 1666 because this is going to tie in with what we're doing when we're talking about the power of attorney and the bills of exchange. This is all going to tie in together, y'all. It's all going to tie in together. I want to read this like this, but y'all see all these different, the way they wrote this, the different wordings, and I know I'm gonna be stuttering like a motherfucker trying to keep up with how they wrote these words and making sure I pronounce it according to how we speak today. And they wrote some of these. So what I did was I went and created, I copied all of this. I did a copy and paste. I copied and pasted, right? And I brought it over here and I did a word spell check, went over and just kind of changed the wording up. Not change the wording, but change the way they spell the thing so it'll look clearer. So when y'all hear what I'm about to read, when me reading this thing, it's gonna make better sense than me trying to read it from this. Because they're just like words like so, absent, absented himself, so they put so S-O-E instead of. I was looking at another chick's video. It was I forgot her name, Tamara. I forgot her last name, but she was going over this and she did a great breakdown of it. But she took time to look at this because she was thinking that this was like a code of some sort. Like, is this meant something else other than just regular S-O, like so, just the way we talk? It sort of kind of remind me of King James version of the Bible, how it just is it words things. This is the way they wrote it. But if you write it in plain English, it makes a hell of a lot more sense. And I'm gonna tell to me, it's more accurate because, and I'm gonna back that up by going into some of these state statutes and read exactly what the state statutes are saying in comparison to my edited version right here. It's gonna match up perfectly. So I'm gonna read this. In action for redress of inconveniences by want of proof of the decease of persons beyond the sea, or absenting themselves upon whose lives estates does depend. I should have said does depend. Okay. Recital that Cestui Que Vies have gone beyond the sea, and that reversioners cannot find out whether they are alive or dead. Whereas diverse laws of manners and others have granted estates by lease or for one or more life or lives, or else for years determinable upon one or more life or lives, and it has often happened that such person or persons for whose life or lives such estates have been granted have gone beyond the sea, or so absenting themselves for many years that the leasers or the lessers, the lessers and reversioners cannot find out where such person or persons be alive or dead, by reason whereof such lessers or reversioners have been held out of possession of their tenements for many years, after all the lives upon which the estate depends are dead, are in regard that the lessers and the reversioners have when they have brought actions for the recovery of their tenements have been put upon it, prove the death of the tenants when it is almost impossible for them to discover the same, for remedy of which mischief so frequently happening to such lessers or reversioners. I'm gonna make this a little bigger, and then I'm gonna bring it up some. I should have made it bigger before I got started. Okay. Cestui Que Vie remaining beyond sea for 7 years together, and no proof of their lives. Judge in action to direct a verdict as though Cestui Que Vie were dead. If such person or persons for whose life or lives such estate have been and or shall be granted aforesaid, shall remain beyond the sea or elsewhere, absent themselves in the realm by the space of 7 years together, and no sufficient and no sufficient and evident proof may be evident proof be made of the life of such person or persons respectively in any action commenced for recovery of such tenements by the lesser or reversioners. In every such case, the person or persons upon whose life or lives such estate depends shall be accounted as naturally dead, and in every action brought for recovery of the said tenements by the lesser or reversioners, their heirs or signs. I didn't know what they were trying to say when they said that. The judges before whom such action shall be brought shall direct the jury to give their verdict as if the person so remaining beyond the sea or otherwise absent themselves were dead. So this is them telling you that they're gonna treat you as if you're dead if there's no proof that you are dead. If there's no proof that you are alive. That's what I meant to say. So this is what this is saying. And I was reading this here with the correction of the spelling. This part right here, and this part right here is what I just read. Damn, I didn't read this part. I thought I did. Hold up. I guess I didn't. That's what I did right there. I guess I'll try this. Let me see. I ain't know I missed none of it. Damn it, man. I don't want to start this over, so let me play with it. Provided always that if any person or persons shall be evicted out of the land, out of any lands or tenements by virtue of this act, and afterwards, if such person or persons upon whose life or lives such estates or estates depend shall return again from beyond the sea, or shall on proof in any action to be brought for recovery of the same, to be made appear to be living, or to have been living at the time of the eviction, that then and from the thenceforth the tenant or lessee who was out of the same, his or their executors, administrators, or assignees shall or may repossess, have hold and enjoy the said lands and tenements in his and their former estates for and during the life of or lives or so long term as the said person or persons upon whose life or lives the said estate or estates depend shall be living. And also shall upon action or actions be brought by him or against them, or them against the lessers or the lesser reversioners or tenants in possession of other persons respectively, which since the time of the said eviction receive the profits of the said lands and tenements recovered for damages and the full profits of the said lands, tenements respectively with lawful interest. So you get it back with interest. Okay, and from the time that he or they were out of the said lands or tenements, and kept or held out of the same by the said lessers, reversioners, tenants, or other persons who after the said eviction received the profits of the said lands or tenements, or any of them respectively, as well in the case when the said person or persons upon whose life or lives such estate or estates did depend are so shall be dead at the time of the bringing of the said action or actions, as if the said person or persons were still were then living. So basically, once you prove that you are alive, you get everything back plus plus interest. So this is what it's saying in the Cestui Que Vie Act, and I'm gonna show you that it says the same things in all the statutes that I look up. Now I can go ahead and delete that. I don't need that no more. So let's see. Let's start with, I'm gonna try to, I've done California before, but I'm gonna do it this time too. And I'm not gonna go all the way through. I'm gonna do a few states. I'm gonna do Minnesota as well, and I'm gonna do Nebraska. Let me just go ahead and get with California. I'm gonna start with, I think it's O2. Presumed dead. Let's see. Subject to the provision to the provision of this part, the estate of a missing person may be administered in a manner provided generally for the administration of estates of a deceased person. So if you're missing, they're going to administer your estate as if you're deceased. Okay, let me go back to 401. In the proceeding under this part, a person who has not been seen or heard from for a continuous period of 5 years, is 5 in California, by those who are likely to have seen or heard from the person, and whose absence is not satisfactorily explained after diligent search or inquiry. So they ain't gonna really look for you for real. Or inquiry. This goes to also go. Well, let me keep going. Is presumed to be dead. The person's death is presumed to have occurred at the end of the period unless there is sufficient evidence to establish the death occurred earlier. Now it's 5 years in California, as you can see. It says 5 years. Now, being at 5 years, and keep in mind, your estate is created when you're born. When you're, during the time when you're born. After 5 years, that's when this kicks in. Okay, it kicks in after 5 years. They're saying after. Keep in mind, these other companies like your light bill, your gas bill, them folk don't know who you are. They knew nothing of your birth. You know what I'm saying? So you grow up and you grow up and you say you get your lights on, your gas, your rent, all that stuff. Those people don't know you. They have nothing. They never knew you from the start, not even the day you were born. So off the rip, you're operating as someone who's deceased when you do these things, unless you give them evidence that you're actually alive. That's where the Builder's Exchange Act's gonna come in. That's why you need a power of attorney when you get involved with this stuff. Okay? Because that's gonna rebut the presumption of death, and you're gonna be claiming your own estate. You're gonna be taking control of it. Okay? Let's keep going. Let's go to Nebraska. In the proceeding under this code, the rules of evidence in the court of general jurisdiction, including any relating to the simultaneous death, are applicable unless specifically displaced by the code. In addition, the following rules related to determination of death and status are applicable. These are the 3 rules right here. Okay, the certified authenticated copy of a death certificate. That's somebody who's actually dead for real. Okay, a certified authenticated copy of any record or report of a governmental agency, domestic or foreign, that a person is missing, detained, dead, or alive, is prima facie evidence of the status. See, prima facie evidence of the status and of the date, circumstances of the places disclosed by the record or the report. A person who is absent himself. Here we go. Who's absent himself continuously for 5 years is okay. You see in Nebraska it's 5 years. Okay? For 5 years, during which he has not been heard from, and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed to be dead. His death is presumed to have occurred at the end of the period, unless there's sufficient evidence to determine that the death occurred earlier. Now, let me see if I can go to, if they have something else in there. No, I ain't gonna do that. So I'm gonna get on out of there. But y'all notice when I had the Cestui Que Vie Act pulled up, it was on a UK website. Matter of fact, let me see if I can go back to that. It's a UK right there. See? Let me see if it. Y'all can't see the top of my screen, but I'm gonna go back there. Here we go. See right here? You see right here? government. That's UK. Okay, that's UK. But as you see, this is all around the world. If you see this, it says the Cestui Que Vie Act. It was originally it was actually written right here, started right there in 1666. But you see it here in every statute that I'm showing you. So it's not just in UK; it's all around the world. It's worldwide. Right here, this is Wyoming. We're gonna read Wyoming. When a person leaves his usual place of abode and is not seen or heard from by his relatives or other persons reasonably expected to hear from him for a period of 7 years, the person is presumed to be dead. Say if the person owned real estate, real or personal property in Wyoming, administration of the estate of the person may be had in a manner provided by law. So you presume to be dead, they're going to administer your estate as if you dead. Okay, so that's why you have to have something in place to stop this bullshit here. They will not be able to administer your estate when you're proven to be dead, when you're proven to be alive. And I'll show you how some of these statutes will actually say that, like directly. And some of them are, depending on what state you're in, what you read. Let me see what it's gonna say if I go to administering without proving will, person represented taking possession of the estate. See, this is what they do. They take possession of the estate right there. A person represented shall take possession of all the estate of the decedent. That's if you're presumed to be dead, or if you're dead for real. Say real or personal. They treat you like you're dead. You know what I'm saying? Real or personal, and collect all the debt due to the decedent of the estate for the purpose of bringing a suit to quiet title for the partition of the estate, and the possession of the personal representative is the possession of the distributees. Okay, we're gonna go now. Let's go to Minnesota. I like Minnesota because it's more detailed. Okay, as y'all see, all these states are saying the same damn thing. So this Cestui Que Vie Act is all around the world. And that's what they do. That's how they do business. So that's why it's very crucial that's why I tell y'all to create records. You have to create some damn records. You can't just sit there and just let these people do shit to you, and then you don't want to create no records to prove that you are alive. Affidavits prove that you are alive. Powers of attorney prove that you are alive. You have to rebut their power of attorney. A power of attorney is nothing if you're not gonna serve the people who's actually administering your estate. You have to serve them. I showed y'all that in my previous videos about powers of attorney. You have to serve them. If you don't serve them, they're gonna administer your estate any damn way. Okay. Now, if a person is in Minnesota, 578.02, absentees right here. See, they may call you missing, or they'll call you absentee, presumed dead, or whatever. If a person entitled to having an interest in property within or without the jurisdiction of this state has disappeared or absconded from a place within or without the state where last known to be, and has no agent in the state. No agent in the state, and is not known where the person is, or if the person having a spouse or a minor child or children dependent to any extent upon the person for support has thus disappeared or absconded without making sufficient provision for such support, and it is not known where the person is, or if it is known that the person is without the state. That means it's not in the state. Anyone who under the law of this state be entitled to administer upon this state of such absentee, if deceased, or if no one is known to be so entitled, some person deemed suitable by the court, or such spouse, or someone in the spouse's spouses or minors' behalf may file a petition under oath in the court for the county where any such property is situated or found, stating the name, age, occupation, and last known residence or address of the absentee, the date or and circumstances of the disappearance or absconding, and the names and residences of the persons, whether members of the absentee's family or otherwise, of whom inquiry may be made, whether or not such absentee is a citizen of the United States, and if not, of what country the absentee is a citizen or native, and containing a schedule of the property. That means a whole list of the property, real or personal, so far as known, and its location within or without the state, and a schedule of contractual or property rights contingent upon the absentee's death, and praying that real and personal property may be taken possession of and received thereof, appointing under chapter 576. No proceeding shall be commenced under the provision of this chapter, except upon good cause shown until the last 3 months after the date on which it is alleged in such petition that such person or disappeared or absconded. So as you see, that was a whole lot more detail, but you see what I'm talking about. Even so, this show is going to go on whether you decide to want to administer your estate or not. This show is still going to go on. As you see, it's all detailed. Let me see what it's going to say if I go forward. See what it's going to say. Warrants, take possession of the property. Let me see if it's going to say anything about when you show back up. That was very detailed. I like how they did that one. Public notice. That's how when they're looking for you. Hearing, dismissal. They got the same process they speak about in Georgia. But let's see, transfer of property. Let's see, receiver possession, additional property. Let's see if you're gonna see somebody coming back behind. Oh, that's when somebody wanna administer somebody's estate. They gotta have a bond put up. Care of property control. Let's see. Advance insurance. Hearing by the court determining the rights. Let's see. Reappearance of the absentee. Here we go. Let's see. Insurance. Let's see. Reimburse. I'm gonna read this. If an absentee is declared dead after advance insurance payments have been made pursuant to section 578.12, the amount payable under the policy shall be reduced by the total amount of the payments made under section 578.12. Reimbursement of insurer. If an absentee is found to be living after advance insurance payments have been made to the beneficiary pursuant to 578.12, the absentee and beneficiary shall reimburse the insurer the amount of the payments made. If the insurer is unable to obtain full reimbursement, I don't know why I'm reading this because it's talking about insurance company. The amount payable under the policy shall be reduced to the extent necessary to allow full reimbursement. Failure of the absentee absentee and beneficiary to reimburse the insurer upon demand for payment sent by the insurer by certified mail to the last known address of the absentee and beneficiary shall be sufficient to show the insurer's inability to obtain reimbursement. Let me see, that's what it's talking about. Let's see, reappearance. Let's see, a court may order the proceeding. Court may order the property to order the property or its proceeds acquired by mortgages, lease, or sale to be applied in payment of charge incurring. It don't say nothing about the oh, it does. It's talking about the spouse or whatever. So prove against the spouse. No, this is not what I was looking for. Let's see, claims of a receiver. But anyway, presumption of death from absence. In absence, who is missing from the continuous period of 4 years. It's 4 years in Minnesota, during which after diligent search the absentee has not been seen or heard from, and whose absence is not satisfactorily explained shall be presumed in any action. That's court right there. Action or proceeding involving the person, the property of the person, contractual or property rights contingent upon the absentee's death or the administration of the absentee's estate. To have died 4 years after the date the unexplained absence commenced. If the person was exposed to a specific peril of death, that fact may be sufficient basis for determining that the absentee died less than 4 years after the date the absence commenced. But as y'all see, it says the same thing in all of them. It says the same thing in all of them. Determination of the death of the absentee. This is why, let's see, degree burden of proof. Declare respondent is no danger. Let's see, marriage. They're talking about a situation where you actually are dead and you're presumed dead. They're gonna deal with your estate whether you're missing or whether you're dead for real. They're gonna your estate is going to be administered. So you have to take control of it as long as you're not. If you're not, quote unquote, lost at sea, you need to be doing something about that. Okay, title of the absentee lost after 4 years. Let's see. I'm trying to see. Let's see. Distribution. I'm just kind of. Okay, that's it. That's the end of that. Okay, so I'm gonna stop right there. I'm gonna stop right here. But I thought I'd make this video to kind of revisit that, so y'all understand the importance of creating your power of attorney, taking control of your estate. You have to do that. Okay, it's vital. We see that this stuff is a very important thing to do. That's part of one. That's a record you can do. Copyrighting your name is one thing, but stopping somebody from administering your estate is a whole nother level. And that's what you're going to use. That's what the power of attorney is for. Copyright is claiming that you are the one that's doing business with that name, but it doesn't stop somebody from administering your estate. So anyway, I'm gonna get on off here, y'all. I'm almost 30 minutes into the video. I thought I'd just show y'all how the Cestui Que Vie Act, of 1666, it's nationwide. It's not just in UK, and all the companies are doing it. All companies are doing it. I even showed y'all, even the Social Security Administration does it. Let's see, presumption. Yeah, they say it too. See, look at that. Presumed dead if he or she is missing from his home, not have heard from for 7 years or more. That's the handbook, Social Security Administration. All over the world, y'all. All companies are doing this. So that's why you have to prove that you are alive. You can't be running around here operating as a fiction. See, keep in mind, a U.S. citizen is the fiction, and they got you operating like that because you ain't got nothing to prove that you're alive, that you are the living man. As long as you don't have nothing on the record that prove that you are the living man or living woman, you're gonna be by default operating as the straw man, as the legal person. The estate itself, the name on the estate, you're gonna be acting as it. Okay, so you need to be making sure that you have your standing right. That's how you're gonna have your standing on point. You got your standing on point when you got something on the record that prove that you are not a fiction. Social Security, as you see, these are all the companies are doing that. That's why you need a power of attorney put in place. Okay, it shuts all that bullshit down. It kills any presumption that you're operating as a fiction. Okay? See y'all in the next go round, y'all. I'm gonna go ahead and get on this video now. Hopefully y'all liked and subscribed already. It don't take me 30 minutes, me talking for 30 minutes for y'all to do that. Y'all should did it already. So hopefully y'all did it already. Hit the notification bell too, so the thing will go off when it's time when y'all see another video pop up. All right, we'll see y'all in the next video. M. Rose signing out.